Artificial Intelligence, Law and Justice. In this class, we are going to see on AI and copyright. As I said in the previous class, this is session 14, first of the 4 sessions on AI and copyright. This is a very hot topic, and then we will also, as I said, look into some of the emerging issues, although we may not go into greater details in terms of case law or the new cases. But we will look at some of the fundamental issues which come up again and again in such debates, and why the AI and copyright problem is not going something that is going to be solved soon. See, fundamentally, they raise a lot of very important questions, not because AI is just a technology. It's a creative technology that would that mimics, that acts as, or that can simply imitate. When the traditional copyright law or practice is based on the notion of author and an authorship, of course, the whole idea of author and authorship has been questioned in the sense that people have claimed whether the idea of author can be claimed as individual, original. All those things have been questioned in different contexts. So, point here is the law, copyright law, envisages author as the creator, but the author may not be the owner, or author may not be the one who holds the copyright, and then identifies with something author with the authorship. So authorship is something which cannot be wished away, which cannot be ignored. If there is a work of art, there is an author, and then author's contribution is also classified as authorship. But can we say in another way, copyrighted works can be used for fair use, for training, educational purposes? In different contexts, there are limitations. In the famous case in India, as you all know, Xeroxing textbooks was permitted as it was considered as fair use. But in USA and other countries, that is a criminal offense, or it's an offense. You would be fined heavily for it. So the applicability of copyright for training purposes in AI, is it applicable or not, is a big question, more like $1 million question. Here, the old issues like fair use are being revisited and challenged. The fair use debate has come up again and again when the digital technologies, or even for Xerox, was brought in, or when people started digitizing images and then started sharing with them. The fundamental thing which we need to understand is technology and copyright issues have been there for quite ages, right from the age of copyright being used to publish books. It has evolved with each technology, and then each time when there was a crisis, or there was issues that looked as insurmountable or unresolvable, technical solutions, irrespective of them, legal solutions have been brought, acts have been amended, rules have been changed, and more importantly, when the digital thing, everything became more prominent, countries went to something like Digital Millennium Copyright Act, so that the Copyright Act covers the impact of digital technology. It also recognizes the potential of digital technology for both production, consumption, distribution of copyrighted works. So the technical issues or the technology which poses issues have been sorted out amicably or not, they have been sorted out. But AI poses a whole lot of new problems. So we cannot simply extract, or you cannot simply say that there is an analogy, we can extend the same logic here. In the 4 sessions, there are a lot of things which we will cover, but this cannot be comprehensive on account of the complexity of the issues. Two, some of the things which we will talk are the ones which come up again and again, so there could be some repetition here. Let us look at the factors that are dominating, or that are the key thing in the discussion. Control. So the importance in managing and directing processes of holding copyright works, creating copyright works, and then who controls, who has ownership, who has the right to control the production, distribution, and sharing of that. Then compensation. If fair use principle is given for AI training, authors will not get any compensation because it's fair use. So if others have to be given compensation and fair and adequate remuneration for the works being used, and what sort of new principles we would need, or should we extend some of the older ideas and then say that based upon the earnings or some sort of royalty should be given to users by the AI companies. We don't have clarity on it. Then the transparency and openness. See, the fundamental problem is that no AI system developer or no AI system company is going to tell you fully that this is what they use for training, or they're not going to tell each and everything about what they used for training. Some bits and pieces might be available. Even for open source models, the information might be available, would be adequate for someone to understand, but that may not be 100%. Or the idea of knowing what exactly had happened when a LLM was developed or when an AI tool was developed by pre-existing material that is already copyrighted is very difficult to find out. And then lack of transparency is a huge problem, because then the authors themselves won't know as to what has been their work being used. Then the legal clarity and legal certainty, as we said, is totally missing, because there are some fundamental issues that need to be tackled. So what do the legislators, policymakers, that they try to wriggle out? One way to look at is that strengthen the powers or the rights of the individual holders, particularly artists and then entities. And when we say entities, it could also be copyright societies, societies that manage the works of the copyrights on behalf of the authors and other owners of the copyrights. Then one approach is to strengthen the position of AI companies by making them, telling that we support innovation, we will ensure that you are not unduly burdened by copyright limitations and restrictions. So expand the scope of fair use, or come up with a solution so that both the creators as well as those who use the system training the copyrighted works are also happy. The recent UK consultation on use of copyrighted materials for use in AI industry became very controversial, because he tried to come up with some solutions which many of the authors and creators were totally unhappy about. But not all countries have taken a clear-cut stand, and in many countries there is absolute lack of clarity on it. And then European Union, as usual, is trying to find some solution, find some solutions, trying to incorporate certain things. And then, given the European Union's long history of trying to quickly address solutions as and when technology raises some problems, is also evident there. So their regulatory measures are broadly compatible, and then they are in tandem with the European Union's larger approach towards digital services, digital economy, and then creative economy. So their approach is very different, comprehensive in one sense, at the same time too complex in another sense. So the country specific approaches on copyright matters is also something very important. But precisely since each country or many countries are trying to come up with their own solutions, or come up with a set of solutions for different in different contexts, we are not seeing any harmonization of that globally on this. Although copyright, the binding agreement for copyright is TRIPS. So in artistic creation, AI is really something acting as a bull in the china shop. It is a new artistic tool. It can create a whole lot of things which you never thought. So is AI as an artistic tool protected by artist freedom under the Article 10.1 of ECHR? We are not, that has to be really thought about. Can AI claim that as an artist have some rights and my artistic freedom cannot be questioned? No, we don't know about it. We have to really look as to how the Europeans try to see these things. Often, if AI can imitate human creative what humans have done, and AI can come up with thousands and thousands of outputs that are identical, that could be indistinguishable from the original output, it's a threat to not only to copyright but also to creativity. And we will see this idea, technological process in reproduction, distribution challenges, cultural industries value chain. See, the value chain here is, I write a book. Then there is someone who publishes it for me. Then there is someone who buys it from him or her. And then there is someone who sells it in the e-commerce platforms or sells it in different versions like an e-book, digital version, bound book, print copy or hard copy. So, and then there is someone who can do certain things in the sense that someone can use the book which I wrote to develop a comic strip. Someone can make a film out of it. Someone else can make a drama out of it. So, copyrighted works are also conceptualized as part of a larger value chain. So the problem with AI is that the technical progress in reproduction distribution is always a problematic one, and then AI makes these things very worse. So it disrupts the cultural industry's value chain. It could potentially disrupt because AI has got huge potential to reproduce, has huge potential to create identical copies, and can also mimic the style. So there are a lot of new copyright wars, and then of course there are crucial questions for the authors also there. But when authors themselves use AI, they can generate images and sounds. They can manually modify or place in self-designed context. So authors can use AI. I can use AI to create a new painting and then identify the use of AI in a specific way in the painting itself, or make a claim and disclaimer that I used Canva for this, or I used this specific Midjourney for this, and then I used my own work and then AI to develop with a new painting. So question here is that AI as a tool is someone primary tool, but for someone it is not an alternative. The sense that if AI as a tool is being created, where is the question of originality comes, where is the question of duplicate and copy comes. So it is cannot be an alternative, it can be a tool, depends upon what the authors or what the artists want to use it. Historically, photography also faced similar issues, acceptance issues earlier. So the point I am trying to raise here is that artistic use of AI is a controversial one because not all artists are comfortable with AI. That could be a personal choice, but that choice also stems from the fundamental fact some artists could see AI as a threat to their creativity and creative freedom. But then this is less to do with that than it is not a simple copyright issue. AI's dependency on copyright material is well known. So often uses copyright material for training. AI must see artworks. So copyrighted images are something which AI has to really see. And for training and other purposes, that has to be reproduced. The images, photographs, paintings, graphs, everything has to be reproduced. So, question number one is involving them for training purpose, is it violation? Or whether the act of AI system seeing the copyrighted works to produce something is a violation, whether it is being totally reproduced or not. Question number two, the generated output might have the copyrighted images as part of that. Then where's the question of liability comes? So if the generated output explicitly infringes on the copyrighted material, the liability has to be brought in, but the current laws are not able to handle it. So the liability here is very complex because AI tool may use an image for some training purpose and then derive something out of it, or can use it in such a way that its usage may not be explicitly visible or may not be explicitly told, but then it could have derived something out of it. So the question here is that where is the input, where is the output, and then what is the way AI deals with these things is a black box to many artists. When an input phase of AI models comes, digitized images are used, material is collected by web crawlers and selected by artists. Most important input material is protected by copyright. Here the problem is if some image is collected by web crawlers and bots that roam the web and then used, is it a copyright violation or not? Then training process, is that a question of copyright infringement? And then it was held that a US company was liable for copyrighted content in learning process, but then that is a very debatable point. So what are the exemptions and limitations for such use? And then this is artistic use, legal precedents, these are some of the things. But more important question is that, as to say, when you do something, when you derive something, or when you combine certain things to come up something new, how does copyright exemptions or how copyright principles adopt or are to be used, or are they valid in the context of AI? This is an important question because artistic freedom actually protects both the process as well as the final artwork. So in the recent controversy where a lot of people used AI to imitate the particular style of a particular one and then came up with their own images, this became a huge issue. Are we such a processes? Are they violating the artistic freedom, or are they imitating the artistic process and then by infringing the rights of the author? We are not sure. Then we need to look into the whole AI copyright word dynamics. The standard argument is that copyright is a fundamental right. It creates incentives so people do write books, compose poems, take films, compose music, and do thousands of things because copyright is there to protect their interest, and then it could be a good source of them in case of misappropriation or using them in a way which the author would not like to use. So it's a fundamental right that motivates creation, that incentivizes creation. And it is also true that some people, particularly in the industry, they have a total blatant disregard for IP rights in the sense that when it comes to copyright, not other way around. Let us be very clear about it. So the point here is there is a whole question of right holders versus creators. Often, sometimes the right holders and the creators have very totally different interests. So economic interests are often designed or disguised as defense of the arts by the right holders who have got economic stakes. And then the real creators' fundamental rights are overshadowed by the corporate interest. And then the right holders focus on existing works because copyright protects existing works. Whereas authors are often focused on the new ones which they can create, which they can derive, for which they can earn money. And in a recent case, a federal judge in Thomson Reuters versus Ross Intelligence said fair use defense in AI training context is not available. So, use of AI as an excuse and then say that I have used it only for in the use of fair use context is not acceptable. Or that defense is not available for those who develop LLMs and other AI products. The political economy of this cannot be ignored because in a recent study commissioned by the US Copyright Office, this is a very interesting study. They made an interesting observation. In Web 1.0, we were worried about the loyal direct rewards for the authors. And then Web 2.0, okay, there are some new channels like YouTube available. You would get indirect rewards, you would get revenue, or you would get money based upon the eyeballs, based upon how many people see you. We have a world where indirect rewards also become a challenge because human creators ultimately will become more anonymous. AI doesn't give you the due credit. It simply absorbs your work without even telling the persons as to whose works and all it has absorbed and then it has used. More importantly, AI uses such lot of work for creating synthetic data and then synthetic output. Unfortunately, authors' works which are used by AI for creating synthetic output may not be even aware of that. So what they are ending up? They are ending up as more anonymous and then suppliers to synthetic output generated by generative AI. So this says there is the need to look at the economic implications of AI for copyright policy. So the copyright policy, what are the traditional economic incentives argued, do not seem to be something that can really work well. So according to Joshua Gans, he again made a study and then said, ex post fair use mechanisms may be better than the traditional copyright regimes. Ex post fair use is that if my work has been used for AI training or for some other purpose by AI systems, after they being used, I should say that fair use, it could be considered as fair use. Some compensation can be given for it, or some mechanism can be made to identify the fair use or users exposed or after the use has happened, and then try to compensate the authors or evolve a system something like the companies automatically give a specified amount to an author based upon the usage of their materials. For example, if a company develops an LLM in law, and then if it has taken substantial chapters from a legal professor's various books, and then if it says that this is fair use, it can compensate the professor by looking at this much is the quantity or this is the number of pages we have used, and then this is the amount which we want to pay you for use, fair use exposed. So that is also possible. Some sort of licensing can be made available. But AI is going to create new issues for creative artists, for others. But many publishers already what they do, they take the copyright to themselves, or the copyright is assigned to them as and when the publisher gets the thing published or gets the article submitted and then approves it for publications. So in that case, what happens? The author almost surrenders every possible right except the moral right of the author, and then the publishers become the de facto owners, and then the publishers become the de facto owners who can negotiate, because technically, although the author is the author, the copyright has been transferred to the publisher. To give a simplified picture, the big five, that is Facebook, Meta, Microsoft, Amazon, Google, and others, and big publishers, music labels, engage in a copyright wars, but creators are someone who are really marginalized because they can have neither the resources to engage in protected legal litigation, nor they might even know which works have been used. So the much of the debate that happens in the label of fair use, incentives for creators, that is why we value copyright as a legitimate right, and then try to create a flexible approach so that we can incentivize AI, and then creating new schemes for rewarding and then redefining limits of copyright protection. The rhetoric is very much there, but then the underlying is the economic rationale, underlying is the cost benefit analysis of each and every option for those who develop models versus those who have the copyright on many of these data or images or the works which are going to be used for developing and training purposes. So we need to pierce the veil of the rhetorics to find the real peace. And given the insatiable appetite, at some point AI will run mostly on synthetic data, and AI can generate its own synthetic data. So what exactly will happen, to for how long this copyright issue will prolong is a matter of debate. And then who is going to really control the subsequent development, direct development of AI? If more and more synthetic data is going to be created by AI companies and then being used, with synthetic data derived from copyrighted works, what sort of things we should be able to monitor, or who will account for such use? Or will that become a broad canvas or broad umbrella of fair use, that anything you use for synthetic data creation is perfectly valid as fair use? So the political economy aspects and gains from valorization to copyright have always been the elephants in the room, whether we like it or not, in the sense that some of these questions have been raised even earlier, and then some of them are being raised now, but they are the elephants in the room, like the political economy aspects of royalty, how much money should be paid when systems are being trained or using copyrighted materials by the people who develop them to the publishers who hold the copyright, and then who gains from the valorization of the copyrighted materials. Valorization will happen when copyright material is being digitized and then sold as a digital product, or further value addition happens through different ways by the artists or by the publishers with themselves in different manners. So the question here is, the political economy in the copyright war is the core of the war, although we can always put it in terms of rights, liabilities and responsibilities of different stakeholders. Another vantage point, it has been well argued, law construction reinforces power in global value chains of AI by providing the foundation for a power enabling form of contractual governmentality, and then by cementing IT fences that perpetuate the uneven distribution of value across the chain. Or in other words, the value across the chain depends upon who holds IP, who has been able to license it, who has been able to make the best of it. For authors, the value chain, they get practically nothing out of it because the IP fence created by the publishers and other copyright owners is the one that makes the difference there. So the law amplifies the geopolitical framing that wants translational AI development to be shaped based on national interest. So ultimately, the global development of AI, the global deployment of AI is good, fantastic. We all talk about it. But the ground reality in each country makes a huge difference. So the variations in the idea of fair use themselves are too huge and they vary across countries. And the national policies on AI also have some strong objectives, or some countries even talk of sovereignty in AI. And then when copyright becomes a contentious issue, will we see that copyright being tweaked to fulfill the national objectives in the sense that, doctrines like fair use, doctrines like fair and adequate compensation, and then doctrines like reuse rights and other associated right or many rights which authors enjoy on account of the TRIPS agreement and other things. Will they be tweaked enough so that incentivization for innovation is much more important than paying some amount for the copyright owners as well as for authors? We really do not know because the battle is just getting heated up now. So how do we strike a balance, or are there any golden rules, or is there a golden mean to address this is an important one, and how they will be negotiated upon, agreed upon is not clear, but in the three subsequent sessions we will try to address them in some other context as well, because the part of the issue here is that copyright issue in AI is not just copyright alone. It is also a question of machine language, machine learning related issues are there. So we need to differentiate the issues. We need to look at the issues in a broader sense of copyright wars, but also in a narrow sense of technological use of copyrighted materials for different purposes in AI. In the next session, we will discuss the legal aspects of machine learning and copyright.